Welcome to Knowledgeable Aging. I'm your host, Jason Kotar. Joining us today to talk about You're Suing Me Because I Kept Your Mom Alive, a discussion of wrongful prolongation of life lawsuits, is Althea Halchuk. Althea is a board-certified patient advocate and started Ending Well Patient Advocacy, where she weaved her past experiences into a business that specializes in giving people a voice in planning the last chapter of their life. She earned facilitator certificates through Respecting Choices and now offers community classes and presentations on advanced care planning and surrogacy. How are you doing today, Althea?
I'm great, Jason. How are you?
Doing very good, thanks. It's good to have you back. So, Althea, I'm going to turn it over to you.
Okay, this presentation is a Final Exit Network presentation, Wrongful Prolongation of Life Lawsuits. You're suing me because I kept your mom alive. That sounds strange, but people are getting sued for that. My job with Final Exit is a surrogate consultant, and I do a lot of education in that role. I help surrogates and healthcare proxies who may be having trouble enforcing an advance directive by giving them in-the-moment guidance to move forward and letting them know their legal rights. Final Exit is a mostly volunteer 501c3 that exists to help people understand their rights and choices. And they'll guide and empower people to make the decisions that work best for them. They don't advocate any particular path. They just help people explore their options and identify which path they want to follow to meet their needs. FEN believes that while death is not a choice, how you die should be up to the individual. Their mission is all about education, options, and choice at end of life. In my program today, I'll review law and court rulings that give patients the right to create advance directives and surrogates the right to enforce them. I'll discuss cases that illustrate consequences if providers ignore your advance directive and surrogates directions. Every competent adult over age 18 can and should have an advance directive. This is the law that gives adults that right. Congress passed the Patient Self-Determination Act in 1990. It gave competent adults the right to accept or reject medical treatment and the right to choose a surrogate to speak for them when they can't speak for themselves. To be clear, a mentally competent adult can refuse any medical treatment, including any life-saving treatments. And that's going to be an important part of this discussion, because a lot of times what patients are doing is rejecting treatment and doctors are forcing it on them. Informed consent. In a 100-year-old ruling, New York Judge Benjamin Cardoza stated, every human being of adult years and sound mind has a right to determine what shall be done with his own body. And a surgeon who performs an operation without his patient's consent commits an assault for which he's liable in damages. So this is kind of, it's more than 100 years old. This law sets the stage for informed consent. And the case was about this woman, a Mrs. Schloendorf, who was admitted to a New York hospital diagnosed with a fibroid tumor. The doctors removed the tumor, but without her permission, and she developed gangrene, necessitating the amputation of several fingers. The court determined that performing the procedure without her permission constituted assault and battery. Even if the procedure is indicated, meaning even if doctors think they should do it, and done properly, in other words, they did it right, the patient has a right not to subject themselves to any known risk that a reasonably prudent person wouldn't subject themselves to. Without a patient's informed consent, it's battery, and it becomes a compensable event. That case led to the creation in many states of informed consent laws. There's a duty to follow advance directives and the surrogate. I keep saying surrogate, but there are other names such as healthcare agent, proxy, medical power of attorney. They all basically do the same thing, mean the same thing. Advance directives are legally recognized documents. POLST and do not resuscitate orders are medical orders. Medical personnel have a duty to respect your wishes and follow your surrogate's directions. They can't override or ignore your wishes because they think they know what's best for you, even if they think they're acting in good faith. If they choose to ignore your wishes, you or your family may have a cause of action against the provider, resulting in monetary payouts. Court damages are typically based on the medical expenses from the time of the unwanted treatment that kept the person alive until their death, and the pain and suffering the patient and family endured as a result. So it isn't just financial problems that come about when somebody's kept alive, even for a day or a week or a year. It's the emotional drain on the family. Doctors no longer have immunity because they kept someone alive. But there's some exceptions to this duty. They can refuse to honor your treatments if they have a conscientious objection because a medical decision or direction violates their religious or ethical beliefs, or they consider your wishes medically inappropriate, or they don't have the necessary skill. You don't want a brain surgeon if it's some kind of other treatment you're looking for that another doctor has the skill to provide. They can refuse if the directive goes against the facility's policies. If you go into a hospital, particularly those with a religious affiliation, that hospital may refuse to honor some of your advance directive. They may not agree to take you off a ventilator, allow you to go without antibiotics, or use a voluntarily stopping eating and drinking, also known as VSED. If it's a religious hospital, they may not go along with that. So it's a good idea to check with your local hospital, the closest one to you, to see what their policies are if you get brought there in an emergency and you have these type of orders in your advance directive. So they can refuse, but what do they have to do? First, they have to inform you and your surrogate right away they will not treat you. They can't wait a week or a month or even, I would say, longer than a couple of hours. If they know they have an objection to treatment, they need to notify you or your surrogate. They must let the patient know what care they are entitled to receive, whether it's from them or someone else, and refer them to another practitioner. And that could be in the same hospital. Maybe this person has an objection on a religious basis or some kind of moral problem, but there's another provider in the same hospital that will treat. If they can't find someone close, they have to help you transfer to another facility that will provide treatment and honor your wishes. And if your doctor or healthcare provider refuses to transfer and still goes against your wishes and orders, the doctor and facility may be liable for damages. So here is the heart of this presentation. It's the wrongful prolongation of life cases. And these cases usually begin with unwanted medical treatment. Physicians, primarily focused on saving lives, don't always consider the legal obligations, implications of their actions. In most lawsuits, a lower court has thrown out a case claiming the provider had immunity from liability. However, higher courts are now reversing and allowing these cases to go forward. Watch for settlements when this happens. Once they are allowed to go forward, insurers don't want them to go before a jury. Unwanted medical treatment. Thad Pope is the foremost authority on these types of cases. He appears as an expert sometimes in these cases, and he's written extensively on this problem of unwanted medical treatment. He wrote in the Journal of Clinical Ethics, patients in the US have been subject to an ever-growing avalanche, his words, of unwanted medical treatment. This is economically, ethically, and legally wrong. Unwanted medical treatment constitutes waste and often fraud or abuse of scarce healthcare resources. It's a serious violation of a patient's autonomy and self-determination. Courts and agencies have increasingly imposed penalties on healthcare providers who deliberately or negligently disregard advance directives and do not resuscitate orders. If someone acts against a directive, they can be found guilty criminally and civilly and may be required to pay damages. They can also be brought before review boards and to explain what they did, and it could involve licensing issues. Medical battery versus medical malpractice. So how are these people bringing these cases to court? I'll illustrate two cases, and each has a different claim. In the first case, they sued for medical battery. Medical battery is similar to regular battery. It's the intentional touching by a medical professional in a medical setting. So some of the examples, well, there's an example. A medical provider performs a procedure such as CPR without the patient's consent. In other words, he disregards the advance directive. So you don't have to prove that the touching caused harm, only that the doctor intended to touch the person. In the second claim, they claimed medical malpractice, and you need 4 elements. You have to prove 4 elements to prove med mal. It's the negligence of a healthcare professional which leads to the patient's injury. It doesn't require proof of intent. So it really doesn't have anything to do with battery. It's all about the duty of the professional. He has a duty of care that is owed to his patients. It's a dereliction of that duty which causes the breach of that duty. It's a direct causation, establishing that the breach caused the injury to the patient, in other words, kept him alive for however long, or in the case of CPR, sometimes if it's on an elderly person, they can break ribs. There's a lot of injury that can be caused by going against an advance directive. And then there's the damages. As I said before, it's not just economic, it's the non-economic losses of watching your loved one, of having to remove them from a life support system that you never agreed to have them on in the first place. So these are the 4 elements that have to be proved. In case number 1, and this lady is Busilla Stevenson. She was 91 years old. She completed her advance directive, and let me just say that about this case, it was one of the first that settled for over $1 million, and if not the first, and so it's quoted all the time. And I suggest when you get done here, Google these cases, because when you read them, your mouth will hang open at some of the things that these doctors do. Them here, I'm just saying, you know, the advance directive says one thing and they do another. So she appointed a diligent agent, her granddaughter, Jacqueline Alicia. She informed her family members that she did not want to be kept alive on any machine, quote, at the hospital, including a ventilator. She was brought to the ER, then the ICU for breathing difficulties. She did everything right with her advance directive, her notification, her conversation with her loved ones. This is what we tell people to do. And she did it all. And her surrogate was also excellent. She specifically directed no intubation, mechanical ventilation without first calling her. A lot of things happened in this case, and she did allow some of the treatments, but if she was going to go on a vent, her grandmother was going to go on a vent or be intubated, she wanted a phone call. Contrary to her wishes, the attending physician had her Busilla intubated and put on a ventilator because she was having trouble breathing. The nurses urged the physician to call the surrogate, as was stated in the medical chart. There you go. The nurses were there. They told him, call the surrogate. He said, and in his deposition, he claimed he would put the vent in, tell the family later, and remove it if they objected. A judge in that case said, it's the will of the patient or designated agent and not the will of the healthcare provider that controls. Big case, big statement, big precedent. And the granddaughter sued the woman. I really forget how long it was before she passed away, but you know, it might have been a month or something. And she was at the end of life, and she had all these issues anyway. So in 2013, her granddaughter sued the hospital, and she was only looking for $200,000 in the medical expenses that were charged from the March 7, 2012 intubation, looking for punitive damages and attorney's fees. So $200,000, the woman was in the ICU for the rest of her life, and that's what they were looking for. After 4 years, because that's what happens, the case gets thrown out, gets brought back, there's appeals. So 4 years later, they settled for over $1 million. The second case, and really, I want you to picture yourself either as the family or the person who's created this advance directive. Walk in their shoes. This one is Dr. Greenberg versus Montefiore New Rochelle Hospital in New York. And that's him, a smiling man. He was a dentist. And at age 63, he was diagnosed with early onset dementia. So he had time. He knew what he was doing. He created his advance directive. In his living will, he specified no CPR, no tube feeding, no antibiotics. This was a man that knew what the road of dementia looked like, and he didn't want to be on that road. The living will named his wife as his healthcare agent, and his sons were also very involved in his care. He was unable to recognize his wife or communicate with her or his children, and he was living in a long-term care facility. I believe he fell, and he was brought to the and given copies of his living will and his healthcare proxy. He also had a MOLST, which is a medical order for life-sustaining treatment, and he stated on that, which was really the controlling document as far as I can see. It was done after his living will, and it was done with his physician, because that's how they're done. He stated he was only to receive comfort measures, no intravenous fluids, and no antibiotics. The doctor at Montefiore, quote, deliberately violated Dr. Greenberg's living will, administering antibiotics and other curative treatments on multiple occasions. And that kept Dr. Greenberg alive for a painful month. The ruling, the New York Appellate Court reversed the lower court's dismissal in March of this year. And they said that the case could go forward. And what they said was a competent adult's right to refuse medical treatment, that's what I said before, and the Patient Self-Determination Act, even where refusal may result in death. It's well established by case law. Their claim was medical malpractice. They said the defendants departed from the standard of care by failing to abide by his wishes expressed in his advance directive. They failed to follow the instructions from his healthcare agents. They failed to follow the patient's MOLST. It was like they were rogue. They had all these documents in front of them. They had copies of them. They had the family telling them, no, he didn't want this, and that with his family for over a month. Had his living will and proxy request been respected, he would have passed peacefully within a day or two, but instead survived in pain for another month. And if you have an infection, what happens is if they don't treat it, it turns into sepsis and shuts down your organs, and you fall into a coma and you die pretty peacefully from what I have seen in my experience. But they kept him alive another month. He was dying anyway, and they just dragged it out. The court in March gave them the right to go forward. The defendant hospital appealed to that, and it would have gone back to the appeals court, except that they withdrew their motion on June of 2022. Compassion and Choices had written a brief for the plaintiffs in this case, and they later said this victory ensures that advanced planning documents are legally enforceable and will be respected by doctors. If they are not, individuals can hold providers accountable for violating their healthcare decisions. So another precedent-setting case. Because the defendant refused to appeal or withdrew their motion, the case is pretty set as a precedent. Here's a few other ones. They're equally as disturbing, I think is probably the only word. A Montana case, Knofel versus St. Peter's Health. It was the first jury award. It was $409,000. The hospital resuscitated him not once, but twice. He had it in his chart. He had it expressed verbally to him by his surrogate. He had all kinds of health issues. He was in a lot of pain. He had spinal issues, and he really didn't want to be resuscitated and kept alive. He also wore a wristband, which goes to show what good those are, because they ignored the wristband as well. They resuscitated him twice. In Magny, it's a California case. The county officials decided they were going to take the surrogate's rights away, and they did. They filed false documents, and a couple of them have been indicted in this case. It's another $1 million case, and I haven't heard what's happened to the county officials as a result of this, but I hopefully they lost their job. In the court opinion, the justices wrote their actions were beyond the pale, appallingly inadequate, and they lacked candor in assessing their conduct. The Bone case was December 2021, so that's recent. A patient sued the hospital arguing they violated the Alaska Healthcare Decisions Act when it assumed decision-making authority over the medical care while he was incapacitated. And his parents were a surrogate, they ignored them too. The Alaska Supreme Court reversed the lower court again. Good faith alone does not provide immunity for failure to comply with a healthcare surrogate's instructions. So the doctor here claimed he was acting in good faith. Well, he took away people's rights, the patient and the surrogate's rights. And then the last one is Wiseman versus Maryland General Hospital. It's settled, but it was an unspecified and satisfactory amount. In this case, the husband authorized a MOLST form for his wife stating no CPR. She was discovered turning blue. Staff performed CPR, which caused broken ribs and collapsed lungs. They defibrillated her with electric shocks, injected epinephrine, and succeeded in reviving her. This case was settled for an unspecified amount in September 2007. So you can see they're from all over the country. It's not just one state, it's all states. These cases, there's a lot of them in the pipeline. Here are some ways to ensure your advance directive is followed, but as you can see, a lot of these people had what they thought were airtight advance directives. Create an advance directive using explicit language about treatment choices and end-of-life goals. Choose an effective surrogate who will fight to follow your wishes. Video your advance directive on your phone or by a professional company. Video is one of the most popular, and they actually will do the video. You'll sit there, they'll record it. They create a little card for your surrogate, which has a QR code, and you just click on that and it gives you, the advance directive gets pulled right up. Have a conversation with your loved one about your choices. That's important. That's probably one of the most important things. Let everybody know what you want and what you don't want. Have your surrogate carry healthcare POA forms and an advance directive at all times. Don't rely on the hospital, even if you know they have them, carry them with you. If you get pushback, you can always contact me for guidance. I'm available pretty much, I'm a phone call away. Here are today's top 10 takeaways, and I have a flyer that I'm going to be sending to Jason with all of these on here. Know your rights as a patient and healthcare surrogate. No, doctors no longer have blanket immunity from liability when they don't follow your advance directive or legal surrogate. Hold their feet to the fire. Medical staff must honor your legal advance directive unless they have a conscientious objection. If staff or a facility refuses to treat you, they must notify you or your surrogate and help transfer to a facility that will. The best way to get the treatment you want is create an advance directive using explicit language about your treatment choices and end-of-life goals. Don't use a boilerplate advance directive that, you know, says things that it's so vague people can't figure it out. Be explicit about your wants and do not wants. Video your advance directive so people can hear your voice, understand your wishes, and see that you have capacity at the time you made the video. And sometimes this doesn't act as an advance directive, it's a supplement. But a lot of times what this does, if you have disgruntled family members who think they know it all and want to treat, sometimes a video will help reassure them that, no, this isn't what mom wanted. Choose an effective surrogate who will fight to follow your wishes. I also have in the resources tips on how to choose an effective surrogate. Have surrogates carry the advance directive and power of attorney when advocating for you. Call FEN's surrogate consultant if you need help, and FEN's lawyer is available pro bono to help members fight for their rights. So just keep that in mind if you want to use the program and I can't resolve an issue.
You had mentioned the word a couple times, competent adult. Can you explain what that means to be a competent adult?
It means that a person is a competent adult or has the capacity to make medical choices, or competency refers to legal and capacity refers to medical. And without getting too deep in the weeds here, a competent adult has the competency required to fill out these documents. They understand what they're filling out. They understand who they're choosing as their surrogate. So somebody under 18 isn't considered competent. That's why you have to be 18 or older. And somebody with advanced dementia may not be competent, but oftentimes they do have the capacity and they can fill out certain documents, especially in the early stages of their diagnosis. I hope that explains it, but.
It does, that does. I want to touch a little bit more, if you don't mind. You were talking about advanced directives and you mentioned the MOLST. If you could maybe go into a little bit more detail about the difference between those two for individuals that may have heard the term advanced directives and are hearing MOLST for the first time, Althea. Sure.
MOLST are their medical orders, and every state has a MOLST now, but it may be called a different thing. So if you type in whatever your state is, or you go to the MOLST website, it's molst.org website, you can see what is named in your state. And what it is advanced directives are based on hypothetical situations in the future. A MOLST form is usually filled out by it's filled out by a doctor and the patient or surrogate, and it drills down to end of life choices where the person may not be expected to be alive in the next 12 months. So they do this because they want to see, doctors want to see in the moment what this person wants. They don't want to have to look at an advance directive and decipher what the patient said 10 years ago when they made this advance directive. This is a document, it's a medical order, it travels with the patient. So if you had a MOLST form and you went home or to a nursing home or back to whatever residence you were living at, that travels with you. They put it on a bright orange, bright neon paper. It's right, the first form in your medical chart. You put it on the refrigerator at your house. And one thing it does is if an EMT is called in an emergency to your house and you do not want CPR, it'll be on the MOLST form. It's DNR, it's a DNR form on the MOLST form. It's part of the form, and they can be held liable if they give you CPR. And that form is, it's present, it's bright, it takes 5 seconds to read it. So it's really kind of an advance directive, but it's better than that.
Yeah. Does a MOLST supersede an advance directive?
It does if the date is, it goes by the date, and typically they always do, because the advance directives are done in a person's life probably when they're not sick. The MOLST comes in when they are sick and when they have to decide whether they want dialysis or a feeding tube or any of those things. So usually it does supersede it. And again, it's like a prescription from the doctor. If this happens, they don't want this. Or if that happens, it's really only like a 1-page form. An advance directive can be many pages, 10 pages. It kind of works alongside an advance directive because it doesn't talk about funerals or memorial services or any of those kind of things that might be in an advance directive. It really is just about treatment. What do you want? What do you don't want? And these are the list of things that there's a check mark that you can, check depending on where you are. One thing I do want to mention that Final Exit offers anybody attending this webinar, and Jason's reach is impressive. And he's got a lot of contacts. A lot of people will have access to this. So you just have to send an email to info@finalexitnetwork.org. Tell them you were at the November 2022 webinar. It doesn't really, you don't need a date, just November 2022 will cover it. And you'd like to receive the 4 complimentary magazines. And it's like a test drive for the membership. And I urge you to go online and check out their website. It's impressive. Nothing in this presentation is to be copied. And I don't provide legal or medical guidance, really. I have a law degree, and so I can help people in the moment with their advance directives and how to enforce them, but this is not medical or legal advice. This is my contact information with Final Exit. The email is FenSurrogate, FenSurrogate @gmail.com. You can call me at 1-800-491-6713. I have a dedicated number with Final Exit. Call that number, you'll get me.
As far as Knowledgeable Aging, you can go to knowledgeableaging.com, see all of our upcoming and archive webinars. You can go to our YouTube page, type in Knowledgeable Aging. We encourage you to subscribe. We update that several times per month. If podcasts are your thing, you can find us on Apple, Tunes, Spotify, etc. Till next time, I'm your host, Jason Kotar, and this is Knowledgeable Aging.